House Bill 813, and there's a PCS, and without objection, the PCS is before us. This is the Pretrial Integrity Act. Representative Bradford, you are recognized to present your bill.
Thank you, Madam Chair.
PCS.
Okay, thank you, Madam Chair and members of the committee. I want to thank Representative Hall, or Chairman Hall, and also Representative Jones. Neither of them could be here, but I asked them to be on the bill because we all know Rep. Jones used to be a judge, and of course Representative Hall is an attorney. But this is the Pretrial Integrity Act. It does a couple of things. This bill was actually brought to me by some folks back that I work with, Police Chief Johnny Jennings out of Charlotte, my District Attorney Spencer Merriweather out of Mecklenburg County, hoteliers. But it does a variety of things. It expands the list of serious felonies for which a judge can determine release conditions. Also expands the list of serious felonies for which a judge could refuse release conditions for a defendant. Requires release conditions to be set by a judge versus a magistrate, extends intervals between custody review. I have heard of zero opposition. I'll duck, but so far I haven't. But my door is open, as I always try to run my legislation. And there will be a friendly amendment, I think, before we get to rules. It won't be here because it's not ready. But I'm happy to run that amendment and rules when we get there. So I would ask for a favorable report. Thanks.
All right, members of the committee, we're open for discussion or questions. If not, Representative Morey.
Thank you very much, Madam Chair. Representative Bradford, what is the need for this bill? What isn't working by setting bonds on anything but capital trials, by having juveniles come in 10 days instead of 30 days? And especially I'm concerned about the part, if anyone is out on pretrial for a charge and gets a new charge, they could be held 48 hours from the time of the arrest without bond. What is the problem we're trying to solve?
Well, I mean, and there's a couple, but I would just point to, there's been a few instances where magistrates have actually let folks be released where it should have probably gone to a judge, and the judge may have ruled differently. So I think it's more about accountability and making sure that judges have those decisions. You know, I just think for my area, we have some very specific examples, and I don't know if we have anyone here from the audience to speak, but where someone was arrested, a magistrate let them go within 30 minutes, and then they went and committed another heinous crime, and the thinking is if that would have gone to a judge because of the class of felony, then they wouldn't have got out right away. So it's really just trying to tighten things up to make it a little more accountable and safer. That's really what I think the intent of the bill, which is why it was brought to me.
Thank you. Follow up?
Representative Morey, you're recognized.
I appreciate it. And just for a comment to that, we always take a few incidents that are bad, but then we try and make it a law that applies to everyone. And if that magistrate made an error in setting a low bond for a person to get out, that magistrate made an error. But for us to ignore innocence until proven guilty, to give bonds or lack of bonds, violates my thinking the right of the Constitution, a right to bail. Magistrates, judges can set $1 million bail if it's a serious offense. The second one is if you're out on pretrial release on a traffic offense and you get in a car and you commit another traffic offense, you can now be held without the right of bond for 48 hours. I don't think our jails have the capacity for that. I think it's denying constitutional rights to people, and I would encourage us not to have a favorable report on this. Thank you.
Madam Chair, yeah, so thank you for those comments. I would just say that when I have a district attorney from Mecklenburg County, one of the largest counties in the states, coming and asking for some help here, I have a police chief, Johnny Jennings from Charlotte, asking for this. I have a lot of other organizations. No one has come to me to oppose this bill whatsoever. Representative Morey, you're the first comments I've heard otherwise. I would just tell you that we need to move this bill. I would ask this committee for a favorable report. And Representative Morey, hey, happy to listen to any concerns you have, but I don't think there's anything wrong with trying to create more accountability in our judiciary system, and that's really what this bill intends to do. So thank you for your comments, but I would ask the committee to give a favorable report. Thanks.
Okay. We have further discussion and further debate, and again, I think I've heard Representative Bradford say he's willing to continue to see if there's some additional thing and maybe share some examples with you if that's what you need. Representative Butler.
Yeah, what's the proposed amendment, Representative Bradford?
Well, so it's not ready yet, but the proposed amendment, give me 1 second. It came from Pretrial Services. I hate to talk about amendment before it's ready, but it's just a couple things.
I
It's
won't hold
adding.
you to it.
I'm sorry?
I won't hold you to it.
That's fine. Yeah, it's adding pretrial services, and it talks about there's a risk assessment that Mecklenburg does. Not all counties do a risk assessment, but it would be if that risk assessment is available, that's something that could be used, and a few other things that all sides seem to be supportive of. And it came from, I think, the pretrial group or association or something. That's how it came to me.
Just one quick comment.
Yes.
I would agree with Representative Moore. I mean, we have a presumption of innocence in this country, and, the philosophy behind our entire judiciary of criminal law, to my knowledge, is that we would prefer one guilty person, go free than others who are innocent be in prison. And to hold somebody for 48 hours without bond is enough time to lose your children, if you have any, even if you're a juvenile. Some juveniles have children, to lose your job. I just feel like also, as she suggested, that this is a circumstance where having the correct bond in place is enough. So I can't support the bill.
Thank you. Representative Green,
Just a motion when appropriate.
further question or comment? I don't have the comment list. Is anyone back there scheduled to speak on House Bill 813? Oh, you've given it to Lisa.
Madam Chair,
Yes, sir.
I am Spencer Merriweather. I'm the elected district attorney for Mecklenburg County. I'm grateful to Representative Bradford as well as Representative Jones and Representative Hall for agreeing to sponsor this bill. I come on behalf not only of the people of my district, but also the Conference of District Attorneys, but also all of the crime victims that I heard from just last week, who literally have seen decision after decision come from our magistrates and say, why wasn't I heard on this? Why didn't anybody hear from me? Because those folks were released before there was a decision that was actually made in open court. What this bill does is actually meet the expectations that most of the general public already thinks happens in the justice system until something happens to them. And so we want an opportunity to make sure that people who have committed these crimes, first violent crimes, have an opportunity to go before a judge, and that judicial discretion is protected within the law. We also want to make sure that people who are already on pretrial release, who then have committed another crime, that again, that judicial discretion is protected, that in open court, victims have an opportunity to be heard, and judges have an opportunity to hear everything that they need to hear. With regard to the particular aspect about how it affects juveniles, this is specified for Class A felonies for folks 16 and 17 who need to be heard from, but we don't have to make the families that have suffered from a homicide come to court every 10 days, merely to come every 30. Because we realize that lightens their load. That would be our ask, and I appreciate the consideration from this committee.
Thank you. And I didn't specify, but we should limit public comment to 2 minutes, staff, because we have so much to do. And that brings me to my other point with the committee. Any bill that doesn't get concluded today will be heard tomorrow at our regular meeting. So hold on to your paperwork so we don't have to copy it again. I see that Jessica Smith has asked to speak. Ms. Smith, you'll be given 2 minutes, and you have the floor. She's going around.
Good morning. To be clear, I'm here on request. The School of Government is non-advocacy, so any comments that I'm going to offer you are not here to argue for or against the bill or any provision of it, but just to provide you some information that can help you in your exercise of your policymaking authority. The one provision of the bill creates essentially a preventative detention statute. It gives the judge the authority, the discretion to say no bail. And it gets at a core problem with our bail system, which is that sometimes really dangerous people can buy their way out of jail with no supervision. In this respect, the thing I wanted to bring to your attention is that the United States Supreme Court has indicated that for a preventative detention statute to be constitutional, it must include certain procedural protections. The court decided a case called Salerno, where it upheld the Federal Bail Act, which allowed for preventative detention precisely because that statute contained a basket of procedural protections. The protections the court identified specifically include things like a full-blown detention hearing, with the defendant having the right to counsel, to present evidence, to cross-examine witnesses, for there to be an individual determination with factors identified by the statute, for there to be a standard of proof. In that case, it was clear and convincing evidence. And for those reasons, the court held that the federal bail statute passed constitutional muster. This is an issue that I've written about. I have a guide for policymaking if anyone is interested in looking at those protections and how they could be incorporated. I have that for your availability. The other thing I'd mention is on the 48-hour hold, most charges in North Carolina are for nonviolent misdemeanors. In 2021, there were 1.3 million charges, 1.2 million were misdemeanors, and 1 million were nonviolent. Most pretrial crime is also misdemeanor offenses, and also even within felony offenses is nonviolent. I present that information to you solely to think about some unintended consequences by having a provision that doesn't limit the 48-hour hold to, for example, people charged with serious offenses and committing new serious offenses. Thank you.
Thank you. And we also have, for 2 minutes, Johnny Jennings.
Thank you, Madam Chair. This is Chief Jennings with the Charlotte-Mecklenburg Police Department. I want to thank you for the opportunity to talk, but first of all, I want to say that we need help. We have to be advocates for our victims. When you have an assault, I can give you examples all day long of cases where we haven't done that for our victims. When you have a young child who is sexually assaulted and the suspect who gets out in 37 minutes does not do any justice to our victims. And we have to have some more integrity when it comes to pretrial bond issues and who we're letting back on the streets. We're not denying bond for anyone. We're just doing much like we have with the domestic violence cases, to where you have to go before a judge in order to get that bond. And when you go before a judge, the accountability to our people is much greater when it's put into the hands of a judge and not just a magistrate. We're not talking about all crimes. We're talking about the most serious violent offenses that deserve, if you've developed probable cause on an individual for those offenses, it deserves to be seen before a judge. And if you commit another crime, and we're not talking about a traffic citation, you're likely not going to jail for that. If you go back to jail, then that would mean that you're going to have to go before a judge for accountability purposes also. So I'm begging you for help for our victims. This is not something that's just for police department or the district attorney's office. We need to be more accountable to the people that we're sworn to protect and serve, and to ensure that our most violent offenders are not back on the streets in 37 minutes for doing a heinous crime or a heinous act, allegedly, that we've developed a probable cause for. Thank you.
Thank you. Members of the committee, further discussion, further debate. I think that's all I had seen signed up for 813. Have I missed someone?
No, Madam Chair. My name is Liz Barber at the ACLU of North Carolina, and Representative Bradford said that no one was opposed, and I just wanted to be clear that the ACLU of North Carolina is opposed, and I didn't sign up for comments, and so I will refrain from.
Madam Chair.
Thank you.
Yeah, for clarity, what I said was I don't know if anyone has opposed because no one has approached me, including the ACLU.
All right.
Thank you.
Thank you.
Further committee discussion. Representative Willis.
I'd just like to echo Chief Jennings' comments on this. You know, we fed one of the divisions in Charlotte-Mecklenburg last week, and, you know, I heard from officer after officer the issues that we're having, especially with some of our juveniles on this. And you know, we've got to have better protections, better support for our victims out there. So I just echo his comments, and thank you.
Representative Morey.
Thank you. Just to comment a second time, I have the same concerns for our victims. And I think any magistrate that would set a bond on a serious offense and get out in 37 minutes, the problem is with that magistrate. we're not focusing on the problem here. We're creating a solution that is too broad, over-encompassing, does not meet federal guidelines and standards of a real hearing if you're denying bond, and I think it's unconstitutional. Let's address bonds with magistrates. Let's teach them. Let's keep victims safe, but this bill is not the way to do it. Thank you.
Representative Green, you're recognized for a motion.
This is a PCS, is that right? Okay. Madam Chairman, I'd like to move for a favorable report to the PCS for House Bill 813, unfavorable to the original with a referral to rules.
I will. You've heard the motion. Those in favor will say aye. Aye. Those opposed will say no. In the opinion of the chair, the ayes have it. The ayes do have it, and the bill will be reported favorably to rules.
Thank you,